Johnson, and I'm a partner in Heptonstall Solicitors, and I am in charge of the Medical Negligence Department. Well, in general terms, they can be from a delay in diagnosis of a medical condition to GP negligence. They can be surgical errors. They can be a delay in referral for a specialist opinion. So there's a variety of claims that you can have in medical negligence. Well, the key thing is you need to see a specialist clinical negligence lawyer, and that's what Heptonstalls are. The reason you need to see a specialist solicitor, you need someone who knows what they're doing, who has medical experts that are familiar with dealing with medical negligence cases, and barristers who specialise in clinical negligence, so that you can be represented with the appropriate people. What we do is we listen to the information that you give us, and we consider any documents that you have, such as a complaint response or any medical records you have, and that in combination with our in-house nurse team, we discuss that and advise you whether or not we think you've got reasonable prospects of success. If you have reasonable prospects of success, then we will arrange funding with you. Usually this is on a no-win, no-fee basis, and we'll start to get hold of your medical records, and then in turn we'll get hold of medical expert opinion on your case and advise you from there whether or not we think you've got reasonable prospects of success. This is quite a difficult question because, as you can imagine, each case is very unique. So it can be from a couple of years to possibly 5 years, depending on the complexity of the case. However, if we're able to establish at an early stage, and if we're able to get an admission of liability at an early stage from the defendants, we can seek an interim payment from them. Again, very difficult question because there's such a broad range of cases and each case is unique. It can range from £1,000 to for a very simple dental negligence claim to multi-million-pound settlement in the case of someone who is injured at birth and has suffered brain injury. Heptonstalls, we're a specialist firm dealing with medical negligence cases. We've got a team of in-house nurses as well as specialist lawyers. We have a database of medical experts that we use, and we are experienced in obtaining millions of pounds in compensation each year for victims of medical accidents. The typical claims process for a medical negligence case is when we agree to take your case on, we get funding sorted, usually on a no-win, no-fee. Then what will happen is we'll obtain your medical records, and from there we instruct medical experts to assist us with the questions of liability and causation on your medical negligence case. If we get positive evidence from our medical experts supporting your case, then we may also want you to be examined by our medical experts to provide a report on your condition and prognosis. Now, from the basis of that medical evidence, we would then, if it is supportive, prepare a letter of claim to be sent to the defendants. Now, the defendants will have a period, usually of 4 months, within which to respond to our letter of claim. Once their response is received, we give that consideration with our medical experts and sometimes with a barrister to reassess your case and advise you whether you've still got reasonable prospects of success. Now, if we have still got reasonable prospects of success but the letter is denying liability, we take the necessary steps to go ahead and issue court proceedings and serve these upon the defendants. The whole court process then takes place, and that can involve a defence maybe admitting liability but perhaps denying causation. We usually find that we reach a point where we've got to exchange witness evidence and exchange medical expert evidence, after which there's a meeting of the individual medical experts for both the claimants and the defendants, and we usually tend to find at that stage we start to enter into some negotiations with the defendants, and most cases tend to settle at that stage. However, if they don't settle at that stage, then we do have to bear in mind that we will have to prepare for a trial. But as I say, this very rarely happens in clinical negligence cases, as usually nowadays we enter a roundtable meeting with the defendants to seek to negotiate settlement of your case. What liability means is we're asking the experts to advise us. Has the medical expert that we're criticising fallen below the standard of a reasonably competent doctor? And if they have, then we should be able to prove your case in terms of liability. What causation means is, but for the negligence, have you suffered any additional damage as a result of those negligent acts or omissions? Such as, have you had a delay in diagnosis of a fracture which has given you mobility problems, or have you suffered brain injury as a result of oxygen starvation at birth? What we try to recover for you is damages for pain and suffering and loss of amenity. This is a figure that is decided on usually by the judges ultimately, but there are case decisions made on individual cases that we refer to, we call them precedents, and we look at those other similar cases to try to advise you where we think your case lies in terms of the value of the general damages aspect of the case, or the pain and suffering and loss of amenity. Special damage is something different from that. These are the out-of-pocket expenses that you have incurred as a result of the negligence claim, and they can be, for example, the additional cost of care that you now need, aids and equipment that you have to pay for, or indeed it could be that you've had to alter your accommodation to now account for the disabilities that you now suffer from. In terms of whether you have to pay anything, the beauty of acting on a no-win, no-fee is if we don't win your case, we don't get paid. If we do win your case, though, we look to the other side to recover our costs, and we guarantee that you will have 100% of your compensation monies.